Trial resumed. Jury not present.
The court said, "Good morning."
Mr. Finkel said, "Good morning."
The court said, "Please make your appearances."
Ms. Murray said, "Good morning, Your Honor. Juliana Murray, Ryan Finkel, and Justin Horton, on behalf of the United States."
Mr. Skirick said, "Good morning, Your Honor. Scott Skirick, Matt Barkin, and Mr. Guo at counsel's table. Ms. Schroff and Mr. Kumraju will join us shortly."
The court said, "Please be seated. So have the parties decided from what section to what section I'll be giving the instructions?"
Mr. Skirick said, "Your Honor, I apologize for interrupting. Mr. Guo doesn't have the translation set up yet."
The interpreter said, "I'm going to give him mine right now, okay?"
The court said, "Okay. Have the parties decided what paragraphs of the instructions you want me to read in my first stage of delivering the jury charge?"
Mr. Horton said, "Yes, Your Honor." So the parties conferred and agree that sections 1 through 5 of the court's charge. So that's the introductory section, the legal section, so to speak, on the counts themselves. And then there's some general legal instructions that follow that would be appropriate before the summations. And then that would leave the sort of deliberation-specific instructions, the two sections at the back of the charge, to follow summations. We think that makes sense.
The court said, "If you could just tell me the pages."
Mr. Horton said, "Yeah." So the first 5 sections go through page 68. That would leave the deliberation instructions from pages 69 to 72 and the concluding remarks.
The court said, "Okay. And when is it that you expect that I would be delivering those instructions just timing-wise?"
Mr. Horton said, "We think those would come sort of after the defense rests their case today."
The court said, Yes. I'm trying to understand when it is the defense plans to rest."
Mr. Horton said, "I think that's a question for the back table."
Mr. Skirick said, "Yes. Thank you, Your Honor. I believe we have the redirect of Mr. Barnett. And then we will resume the direct of Ms. Lee. I think our best estimate is that Ms. Lee's, if I understand from Ms. Schroff correctly. Our best estimate is Ms. Lee's direct testimony is probably, somewhere short of 90 minutes. Of course. We have no idea what the cross will be, the length on that. And then the final witness, Mr. Higginbotham, I expect. Barring any objections that sort of slow things down. That Mr. Higginbotham's direct can be accomplished within probably 45 minutes. So I think that my rough math would be that we ought to be done perhaps right after the 12 o'clock break or the 11:30 break.
The court said, "Good."
Mr. Horton said, "Just one related thing to add. We have a consent proposal, I'm happy to say. Parties agree on an addition. It's a conforming edit to page 24 of the court's jury charge."
The court said, "Okay."
Mr. Horton said, "There's a sentence added by the court and described at yesterday morning's conference. This is the last sentence of the first paragraph on page 24. It's in the materiality subsection of the securities fraud charge."
The court said, "Okay."
Mr. Horton said, "The sentence currently reads, materiality is judged as of the time the information was disclosed. So we propose adding, or omitted, just to conform with the statements or omission structure throughout the rest of the charge. Honor."
Mr. Skirick said, "No objection from the defense, Your."
The court said, "No problem. I will add that."
Mr. Horton said, "Thank you, Your Honor. We have a few other matters to raise."
The court said, "Okay."
Ms. Murray said, "The next matter, Your Honor, relates to George Higginbotham. We spoke yesterday morning about his testimony and the fact that he was a DOJ employee at the time of his offense conduct in the separate conspiracy. We've spoken with defense counsel. We've reached agreement on a limited number of questions that they would ask to elicit the fact that he was a DOJ employee and to establish what the nature of his job was at DOJ. I expect to include that he did not work on criminal investigations or criminal prosecutions. That would be the scope of what the parties have agreed. And then the government, of course, could inquire on that same limited scope on cross-examination."
The court said, "So he was an attorney?"
Ms. Murray said, "He was an attorney, yes. He was an attorney advisor and a congressional kind of policy person.
The court said, so he was not a prosecutor.
Ms. Murray said, correct.
The court said, okay.
Ms. Murray said, and then with respect to that part of Mr. Higginbotham's testimony. I know we've gone over the government's request for a limiting instruction. We previously proposed a limiting instruction that indicated that this prosecution is lawfully brought by the United States of America, and that it's not being influenced by the Communist Party. The government now would ask, and we understand that it may be over defense objection, but just for the very factual and accurate statement, that this prosecution was lawfully brought by the United States of America, full stop, after the DOJ employment is elicited in Mr. Higginbotham's testimony.
Mr. Skirrick said, so, Your Honor, two things with respect to Mr. Higginbotham. One is I just wanted to make the court aware that consistent with Your Honor's instructions yesterday, I have communicated with Mr. Higginbotham's attorney to convey the court's instruction that Mr. Higginbotham avoid affirmatively raising the fact that he was a DOJ employee beyond what the defense and the government have agreed are appropriate questions on his direct and cross. So just to tick and tie that off for the court. And then to address Ms. Murray's request for a limiting instruction. Frankly, Your Honor, this is just another attempt, another bite at the apple. Your Honor has already denied the government's request for that limiting instruction yesterday. Both parties wrote letters to the court over the long weekend with respect to it. Your Honor considered it and rejected it. We don't think there's anything that's happened since then that would warrant any change in the court's ruling, particularly given the parties' agreement on the appropriate scope of questioning with respect to Mr. Higginbotham's appointment by DOJ.
The court said, if you would just repeat, Ms. Murray, the instruction that you're asking for.
Ms. Murray said, yes, Your Honor. The instruction would be, this prosecution was lawfully brought by the United States of America. And just to elaborate briefly in response to Mr. Skirrick, the reason that we're asking for this, and again, this is a very truncated version of the prior limiting instruction, is it is a fact that this prosecution was lawfully brought by the United States of America. It's a fact, but we want to make sure that the jury is aware of that, because we think it is possible that they are not necessarily aware that there's no question about the lawfulness of this prosecution.
The court said, so when I made my decisions with respect to the instruction, I did not know the full scope of his testimony. And so I do, having heard more yesterday, I do believe that the instruction is appropriate.
Mr. Skirrick said, Your Honor, if I may just briefly on that. We understand the court's reasoning. I believe that ordinarily this type of instruction is not something that's given in typical cases. It's usually only given in the context of where there's a defense or where there's an argument by the defense of selective prosecution, which, of course, has not been the case here. So I just wanted to note that for the record, Your Honor. We continue to believe that it's unnecessary, but we understand the court's ruling.
The court said, this is an extraordinarily unusual circumstance where an individual, who is an attorney and employed by the Department of Justice, got himself involved in a scandalous scheme that goes to the very core of a lack of patriotism, a lack of his allegiance to his oath. It's a very rare circumstance, and I am afraid that the jurors may think that somehow his conduct infected the rest of the work of the Department of Justice.
Mr. Skirrick said, I certainly understand Your Honor's point. I think the only thing that I would add is I fully expect that the government on cross with Mr. Higginbotham will elicit that he was not a prosecutor. He worked in the Office of Legislative Affairs of DOJ in Washington. And they will also likely elicit that this scheme was, frankly, interrupted by the FBI and that it was not brought to fruition, despite the co-conspirators' attempts. And so I think there is probably enough that the government will do on a cross to draw the sting that, or the potential sting that the court is identifying. And frankly, the need for any sort of affirmative instruction is taken care of by what the government can do on cross, Your Honor. But, again, we understand the court's point, we just maintain the objection.
The court said, anything further?
Mr. Finkel said, yes, Your Honor. One final issue from the government. The government gave further review to the defense's July 8th letter, which was a response to the government's request for various jury charges, which the court addressed and dealt with primarily yesterday. But there's a factual issue embedded in that letter, frankly, which we didn't appreciate until later. and we just want to make sure that the defense does not make arguments that are improper and not based in the evidence. Defense's letter states, and this is the July 8th letter, that they intend to argue through because of witness testimony concerning the Chinese Communist Party's coercion of GTV investors, plural, into filing false complaints, plural, with the FBI concerning this case. And they go on to suggest that the jury should be able to consider that the CCP tampered with witnesses when they consider, I suppose, Guo's intent. There is testimony about 1. False filing from a defense witness, Mr. E. As the court was clear in its order on Tuesday morning, that witness, quoting from Your Honor, this is page 4764 of the transcript, cannot testify as to the intent or motivations of the government's victim witnesses, nor can he speculate that the victim witnesses are biased in favor of the CCP or are CCP spies. Moreover, Defense Witness 1, now we know is Mr. E, cannot testify that the Chinese authorities wanted to use a fraud case to bring down Guo. A speculative claim. Your Honor went on to say that to the extent that testimony has any probative value, it risks creating an inference that the prosecution team is improperly linked to the CCP or in any way malicious, which I have previously forbid Guo from arguing. And you cite your order at 13. So, Your Honor, while they can, I suppose, argue that Mr. E himself was coerced into filing a false complaint, they cannot, by your own order, use Mr. Yi's testimony and supplant what he did onto any of our victim witnesses, or any other witness, any other victims, who did not testify. To the extent that victims had intent to, I don't know, file a false claim or whatnot, has low relevance. What the jury is considering is Mr. Guo's intent. And so the application, Your Honor, is to ensure that the defense does not use Mr. Yi's testimony for an improper purpose and make an inference that Your Honor has forbidden. And it appears from the July 8th letter that that's exactly what the defense is intending to do. So we just want to make sure that doesn't happen, so we don't have to object during the closing.
Mr. Skirek said, so, Your Honor, just first to be clear on the sequence of events. I believe the ruling that Mr. Finkel referred to came prior to Mr. Yi's testimony. Southwest, the court did not have the benefit of having heard the full scope of Mr. Yi's testimony before having made that ruling. Mr. E testified, if memory serves, that not only was he coerced, as everyone heard, into filing false complaints with the FBI, the DOJ, the SEC, and the New York Attorney General, among other authorities in the U.S. He testified that the CCP agents who he interacted with on multiple occasions when he was detained said that this was how they planned to bring down Mr. Guo. That is how, that was part of the plan. So based on that testimony, we should be permitted to argue that that was the CCP's goal and that was the means by which they aimed to achieve that goal. Now, Your Honor has made clear that, certainly there are limits to our ability to make that argument. Look. Bias, as we all know, is never collateral. And we ought to be able to argue in closing that this raises questions about bias of the complainants who have contacted government authorities in this country, including the Department of Justice and the SEC. And that is not an inference.
The court said, how is their bias implicated?
Mr. Skirek said, Your Honor, to the extent that there are individuals in China who contacted government authorities here. Like Mr. E, I think the testimony that Mr. E gave that, as I said before, the CCP's plan was to coerce people into making false complaints, goes to the potential bias of other complainants.
The court said, so I'm just not following your argument at all. I don't get it.
Mr. Skirek said, so, Your Honor, if Mr. E testified that the CCP told him, the agents of the CCP told him, if I'm recalling this correctly, we will confirm. To the extent there's any question about the facts, I just don't, frankly, have it in front of me. My recollection is that Mr. E testified that the agents told him that this was how they were going to bring down Miles Guo, was by coercing individuals in China. who we all know made up the large majority of the folks who sent money for the investments at issue, were based in China. Right. So if that's a fact, and it's a fact in evidence that the CCP planned to coerce people in China into making false complaints, the defense ought to be able to argue to the jury in closing that that is something that has likely happened with respect to others besides Mr. E.
The court said, "This is a very hard no. No, you cannot make that argument. There is no evidence that the CCP coerced the victims in this case."
Mr. Skirek said, "And Your Honor, I think there's a distinction that I'm trying to draw, perhaps inartfully, between the victims that the government has called in this case and other complainants."
The court said, "So that would be just speculation. You don't have specific evidence."
Mr. Skirek said, "Well, I mean, Your Honor, I would suggest to the court that Mr. E's testimony about this plan by the CCP takes it out of the speculative land. He had said that that is what he was told. That's evidence of the CCP's intent, methods and means by which they have gone about undermining Mr. Guo, attempting to undermine Mr. Guo. And he is a representative example of that. And so, you know, again, putting aside the government's victim witnesses, which, again, are a small subset of the entire population of individuals that the government contends are victims here, we ought to be able to argue in fairness and based in fact on evidence that is in the record that it is conceivable that other victim witnesses have been coerced by the CCP, the same way that Mr. E was."
Mr. Finkel said, "Just a few points, Your Honor. 1. I don't believe that Mr. E testified that the Chinese Communist Party told him they were trying to take down Guo through a fraud case. And the reason he didn't testify to that, or I don't have a recollection of it, is because that was my witness, and I would have objected. And the reason I would have objected is because Your Honor excluded that testimony correctly. Defense Witness 1, this is 4764 of the transcript, cannot testify that Chinese authorities wanted to use a fraud case to bring down Guo's speculative claim."
The court said, "Let me just interrupt you for one moment. Mr. Skirek, if you could please point us to the part of the transcript where you say that the witness said that it was the CCP's plan to bring down Miles Guo through these complaints."
Mr. Skirek said, "We are trying to find it right now, Your Honor." "Yes, we're attempting to find that now."
The court said, "Okay."
Mr. Finkel said, "A few other points. The targeting evidence, which we've stipulated to in large part, is relevant because it shows that Mr. Guo's thoughts about being persecuted by the CCP were objectively reasonable. That he wasn't paranoid, to use the court's phrasing. That's why it's relevant. And we're not disputing that at all. To use Mr. Yi's testimony to supplant it, 1, on our victim witnesses, would be speculative and forbidden by the court's prior order. And I understand Mr. Skirek is not asserting that. What he's asserting actually is in some place worse. He's saying that the victim witnesses, who the jury has not heard from, are biased in that they filed false complaints. Okay. Number 1. Their bias isn't relevant because they weren't witnesses. That's number 1. Number 2. It doesn't matter their motivation for filing a complaint. What the jury is going to consider is whether the government has proven beyond a reasonable doubt whether Miles Guo had an intent to commit a crime. Not whether the filings of witnesses that didn't testify were true or not true. At its heart, Your Honor, what the defense is trying to do is use their witness to paint a broad picture about other things the jury has not heard about. That is using speculation to make an argument. And it goes to this ongoing theme where the defense very strategically is saying, this table? We're not CCP agents. We're not arguing this table is CCP agents. That's not our argument. We're just arguing everything around them is tainted by the CCP. And that the 4 of us and the FBI agents that we've worked with for the last couple of years had been unwitting tools in some sort of plot to take down Miles Guo. All of that is not proper. The question for the jury is Miles Guo's intent. And while they're certainly free to say that our witnesses were biased or lied, they did not ask our witnesses, "Did you file a false complaint? They did not cross our witnesses on what they used Mr. E for. So to do this strategic, tactical approach of not asking our witnesses, and then impeaching them through their witness, and then using their witness to speak to the motivation of individuals who aren't even part of this trial, because their testimony is not in it, is improper. And Your Honor already ruled that they shouldn't be able to do it. So I'd ask the court to adhere to Your Honor's prior ruling and make sure that the defense not argue that our witnesses filed false complaints at the behest of the CCP. And certainly not that other victims, who the jury did not hear from, filed false complaints. And Your Honor, this is consistent with a Second Circuit case, U.S. v. Bautista, 252 F.3d. 145, 2 DCR 2001. Second Circuit quoting, a district court has broad discretion in limiting the scope of summation. That was affirming a conviction of a defendant who complained that the summation was improperly limited. The court, as I understand it, precluded the defense from making arguments that weren't supported by the facts that were elicited at trial. That, of course, is an appropriate use of your discretion. We ask the court to adhere to its prior rulings and do so.
Mr. Skirek said, Your Honor, if I may, excuse me. Just briefly. First of all, we had no notice that the government was going to make this argument this morning. It's obviously a very important issue. We would like to make sure.
Mr. Finkel said, we've been making this argument for weeks.
The court said, Mr. Skirek, this has been at the core of the case, so this cannot amount to a surprise.
Mr. Skirek said, No, I'm not saying it's a surprise, Your Honor. I'm sorry if that's the impression I left. My point is we're looking for the testimony, we just weren't prepared to be able to put that in front of the court. And I think it's obviously an important issue. And we would certainly like to have the opportunity on that. Given the court's observation that we agree that this is an important issue at the center of the case. So that's number one. Number two, look, I just want to reiterate what we've, I think, made abundantly clear repeatedly. The defense has no intention whatsoever of making the argument that this prosecution and this prosecution team is somehow a tool of the CCP. Clearly that's not going to happen. Mr. Kumraju stated that repeatedly on the record. We've represented that to the court over and over. There is a difference, however, between that on one hand, and on the other hand being able to argue about the bias or potential bias of complainants. And not just the victims in this case, but others. And that is what we're seeking to do.
The court said, so it's appropriate to sum up on the issue of bias, and that goes on a witness-by-witness basis. You cannot generalize from Mr. Yi's individual experience. You cannot speculate that he represents the majority of the complainants, because we have no evidence about any complainants other than the ones who testified here.
Mr. Skirek said, Your Honor, I think.
The court said, don't invite them to speculate. That's my ruling. I cannot be more clear about this.
Mr. Skirek said, Your Honor, I would just point out two other facts. One is we will try to find this record citation that I was referring to before in Mr. Yi's testimony. There is also testimony from a victim witness Yili, also known as Mulan, who testified that she believed that in order to go back to China to be able to visit her parents, she had to disclaim any association with Miles Guo to be able to safely travel back there. There is certainly other evidence in this case that we can point the court to that ought to allow us to make the argument about bias that I'm referring to. A parallel point here, Judge, is, of course, Your Honor has ruled with respect to going back to May on the fox hunt order, that the Chinese government's methods of trying to undercut and discredit Mr. Guo are also highly relevant, and also have obviously been the subject of a lot of evidence that's been introduced in this trial. And this is just further evidence of that as well. So it not only goes to bias, but is also relevant to the Chinese government's targeting of Mr. Guo, and the means and methods by which they targeted him that have impacted his state of mind and what he's done here. So I think it's relevant for both of those reasons, Your Honor. And if the court would permit us to just gather our record citations to be able to present that to the court perhaps at the 11:30 break so that we can have a full record before the court.
The court said, "Of course you can present me with whatever portions of the transcript that you think are relevant. But I am not inclined to permit any form of speculation. Is there anything further?"
Mr. Skirek said, "Your Honor, we have one additional application that is relevant to the testimony of Mr. Barnett, who is still on the stand, on redirect. Yesterday during cross-examination, there was a series of questions asked about Mr. Barnett's role with respect to the Taurus Fund, which the court may recall is the intermediate entity that was the owner of the MOA property. And Mr. Barnett, on cross-examination by Mr. Ferguson, stated in sum or substance that he believed that the paperwork that he signed made him the owner of that fund that, in turn, owns MOA. Now, that is incorrect as a factual matter. And unfortunately, I'm sure this was not on purpose by Mr. Ferguson. But Mr. Ferguson on cross picked up that misstatement and continued to ask the witness whether he was surprised to learn that he was the owner. Whether he first learned that he was the owner during the bankruptcy proceeding. And, of course, the government knows that just as a matter of basic, LLC law, being a manager or a member of an LLC does not make one owner of the entity. So we would ask, Your Honor, that testimony be stricken as misleading. And, of course, those are facts that the government well knows. And that testimony was improper.
Ms. Murray said, "Your Honor, just briefly on that point. It's entirely appropriate testimony from Mr. Barnett. It's his understanding of what happened. He was stating facts. I would also note, like Lejeune, Mr. Barnett is not a lawyer. He is not drawing legal conclusions. He is stating his understanding. Paperwork was put in front of him, he signed it, and what he understood that paperwork to represent." Just a moment. Please, Your Honor. And, Your Honor, would just note it's akin to Mr. Dragon's testimony. He testified to his understanding regarding the GTV stock shares. That wasn't based on necessarily personal knowledge. It's factually inaccurate based on the government's case and the facts. It was not struck, however, because it's his understanding. So similar to that, Mr. Barnett testified to his understanding appropriately. There's absolutely nothing improper about that. There's no basis, zero basis, to strike it. And I would also note that's what redirect is for. He's their witness.
Mr. Skirek said, Your Honor, just briefly. The dragon comparison is apples and oranges. Our point here is that the government knows the actual facts, yet on cross. They picked up on a witness's mistake and they adopted his mistake and continued to ask questions in the same vein that suggested to the jury that he was the owner of the entity, when the government knows he is not.
The court said, "So are you arguing that the government acted in bad faith?"
Mr. Skirek said, "No, Your Honor. As I said before, I don't have any reason to believe it was intentional, inadvertent. Doesn't matter. At the end of the day, the question is I believe the representatives for the parties would agree that was factually incorrect and left an incorrect perception with the jury. And the issue on redirect is because this witness is not someone who necessarily appreciates the distinctions between a manager or a member or an owner. That our ability to deal with this on redirect is very limited and it will have left a misleading impression with the jury on a critical issue. Your Honor, a very critical issue. Obviously, who owns MOA is perhaps, the issue or one of the handful of issues that are at the center of this case. And to leave the jury with the impression that somehow the people who, in the government's telling, worked for Mr. Guo, duped Mr. Barnett into signing paperwork that made him the owner, without his knowledge, is highly prejudicial and it's not clear that that's something we're able to clean up on redirect.
Ms. Murray said, Your Honor, just briefly. What Mr. Skirek just stated is factually true. That's exactly what happened. It's consistent with the means and methods of the RICO conspiracy that the government has presented over the last 6 weeks. Paperwork was created. People signed it. It wasn't Mr. Guo. It will surprise no one to learn that during summations. The government is going to argue that Miles Guo was the owner of the MOA mansion, With respect to Mr. Barnett's understanding of what certain paperwork meant, that's his understanding. He also understood that he was the manager of MAWA. And he testified that he thought manager meant security manager, not manager of a fund. Again, the defense can redirect him on that. They can confirm that was his understanding. They can argue in summation that that's not what happened based on LLC law, to the extent that that's in the case. But there is no basis to strike, to limit. It's entirely appropriate for him to testify to his understanding.
Mr. Skirik said, "Just one last point, Your Honor. What you have not heard from the government in the discussion on this so far is that the government knows that that is incorrect. That Ms. Murray didn't address that at all. If the government knows that being a manager of an LLC does not make one the owner, which I think we can all agree with, then any questioning that compounded that misunderstanding is improper. Particularly in light of our potential inability to rehabilitate that on redirect. And it risks leaving a very serious misimpression with the jury that we're not able to cure."
The court said, "So part of what a jury does is to assess a witness's intelligence, how well informed they are, how they perceive their reality, and this was his belief. He said he was the owner. The prosecution picked up on that. You call it a slip-up. Well, sometimes your witnesses slip up and you just have to live with that. You will address that on redirect."
Mr. Skirik said, "Thank you, Judge."
The court said, "Let's get the jurors and the witness, please."
Jury present.
The court said, "Please be seated. Good morning, jurors."
The jury said, "Good morning."
The court said, "I apologize for bringing you out 5 minutes late. I had to clear up some matters with the parties. Alrighty, let's have our witness brought back to the stand."
Witness present.
The court said, "Remember, Mr. Barnett, you're still under oath. You may be seated."
The witness said, "Thank you."
The court said, "And you may continue the inquiry."
Ms. Schrofa said, "Thank you, Your Honor."
Gerald Scott Barnett, called as a witness by the defendant, having been previously duly sworn, testified as follows. Redirect examination, continued, by Ms. Schrofa.
Good morning.
Good morning.
Mr. Barnett, yesterday when we last spoke, we were talking about the timing of the DOJ seizures that the prosecutor had asked you about. Do you recall that?
Yes, I do.
Mr. Barnett, is it fair to say that, sitting here today, even now, you do not know anything about these DOJ seizures?
Ms. Murray said, asked and answered.
The court said, sustained.
Sitting here today, do you recall the dates that you spoke to Yvette about renting out motorcycles?
I don't have exact dates for that.
Mr. Barnett, you were shown GXWA26. If I could have that pulled up for you. You recall being shown this document?
Yes.
And you were asked to read from it, correct?
Yes, I believe so.
Had you ever seen this document before yesterday?
Yes, I've seen it before.
And when did you see it?
Now probably about a year ago was probably the last time I actually saw it, give or take. I don't have an exact date on that.
And who showed it to you?
I don't think anybody showed it to me. I believe it was on my computer.
Okay. When you met with the United States Attorney's Office, they didn't review this document with you, correct?
Not that I remember, no.
And they asked you questions about your discussions with Yvette about a Lamborghini. Do you recall that?
Ms. Murray said, objection, Your Honor, unless the limited yes or no, as with yesterday.
The court said, you may answer yes or no or I don't recall or I don't know.
Sorry. Can you repeat that, please?
Sure. You were asked questions yesterday about a Lamborghini. You remember that?
Yes.
And then you testified about discussions you had with Yvette regarding that Lamborghini, correct?
Yes.
And sitting here today, you don't recall when those discussions occurred, correct?
Ms. Murray said, asked and answered.
The court said, sustained.
Do you know where that Lamborghini was?
At the time of those conversations, is that what you're asking?
Yes.
I believe it was in a residence in Connecticut.
Okay. And do you recall if it was moved?
Not that I'm aware of, no.
Now, let me show you what is marked in evidence as SB 212. By the way, Do you know how many garages there are at the residence in Connecticut?
Yes.
How many?
4.
4?
There's 4 garage doors, correct.
Thank you. Ms. Schrofa said, could I have that pulled up again? SB 212. This document is an evidence, Mr. Barnett. You can believe me when I tell you that because it has the little sticky on the document below. And you recall getting this email? You see that, your name right on the left side?
I see it. I don't recall receiving the email, but I do see my name on the top.
All right. Ms. Schrofa said, well, let's scroll down. Let's keep scrolling down. There we go. You see the text of this email?
Yes.
And you remember yesterday being asked questions about this boat or ship, whatever it's called. I don't know what it is actually, a boat, a ship, a yacht, Liberty?
Yes.
Okay. Did you have any involvement with the maintenance and upkeep of this instrumentality?
No.
You see these progress reports that you were sent emails about?
Yes. Please.
Ms. Schrofa said, can you scroll down for Mr. Barnett? You see all the things it lists?
Ms. Murray said, Your Honor, just one note. This document is not in evidence. The government doesn't object. But it needs to be formally admitted.
Ms. Schrofa said, it was the government who showed it on their cross, so I'm happy to admit it or, well, I move it admit it.
Ms. Murray said, no objection.
The court said, it is admitted.
Defendant's Exhibit SB 212 received in evidence. By Ms. Schrofa.
You recall yesterday the prosecutor asking you about a document named SB 212?
Yes.
Okay, let's scroll down, shall we? Do you have any recollection of what is being discussed in this email?
I don't recall the email. I recognize some of the pictures in the email, but I don't recall the actual email that I received.
Was this the boat that was in purse shape and had to be sent back?
Yes.
Ms. Schrofa said, thank you. You can take that down, please. Mr. Barnett. You remember yesterday you were asked a series of questions about the left and the right wings in MAWA?
Yes.
And you testified that you did not believe that Mr. Gua and his family were going to live in MAWA. Correct?
Ms. Murray said, objection. Mischaracterizes his testimony.
The court said, sustained.
Did you believe that Mr. Gua and his family were going to live in MAWA?
Ms. Murray said, asked and answered.
The court said, sustained.
Ms. Schrofa said, it's not. There isn't an answer, Your Honor. He didn't answer it.
Ms. Murray said, this was covered extensively yesterday, Your Honor.
Ms. Schrofa said, I'm on redirect.
The court said, the intended use of the property was gone over by you.
Ms. Schrofa said, yes, but this is redirect, Your Honor. I haven't asked him since they did their cross.
The court said, you are not to elicit, you are not to repeat the same questions that come from the direct.
Ms. Schrofa said, this is from his cross. The wings only came up on cross.
The court said, no, I don't think so. If I'm incorrect, I'm happy for you to point me to the portion of the transcript.
Ms. Schrofa said, may I have a minute, Your Honor?
The court said yes.
Ms. Schrofa said, thank you. Your Honor, could we have a sidebar?
The court said yes.
Ms. Schrofa said, thank you.
Continued on next page. At sidebar.
The court said, I do have the direct.
Ms. Schrofa said, yes, Your Honor.
The court said, one moment please. I'm going to have him print the portion of the direct in which he testifies about the different wings.
Ms. Schrofa said, and then the government crossed on 5518. So I'm allowed on redirect to address the points that they brought out on cross. That's correct.
The court said, what I'm saying is you can't risk the same questions.
Ms. Schrofa said, I can under the rules, Your Honor, if they brought out something on cross. I think.
The court said, so I'm the one making the rules, and I'm saying that you cannot repeat the same question that was already asked on direct.
Ms. Schrofa said, even if the issue was addressed on cross, Your Honor?
The court said correct.
Ms. Schrofa said, so I just want to make sure I understand. So my redirect is limited to things that were never brought up on direct, even if they crossed on it?
The court said no. My point is that you have already, during the direct examination, covered this area. Now I'm going to go to page 5448 of the transcript.
Ms. Shrofa said, 48?
The court said, 5448. This is the direct examination of the witness, Mr. Barnett. At line 19, Mr. Barnett, were their names attributed to different rooms within the facility? Answer: yes. Question: what were the names? Answer: I'd have to look at the map, but the ground floor, I don't remember that having a name. The second floor. One side was Miles' wing. The other side was Madam's wing, which was Miles' wife. And I believe on the third floor one side was for May, and the other side was for his son. So this has been covered.
Ms. Shrofa said, so the question I asked was about rooms, and he answered with wings. Then on cross. The government asked, they weren't just bedrooms, correct? These were whole wings? That's correct. They were multi-room portions of this mansion that were just 4, and then they go on to ask again about all of the areas. And then they question him about Brioni suits. They weren't just bedrooms, they were whole wings, correct? This is on the cross.
The court said, so let's just identify the page of the transcript.
Ms. Shrofa said, 5518.
The court said, okay. Go ahead, Ms. Murray.
Ms. Murray said, if I may briefly, Your Honor. Your Honor has ruled already. We consistently have this issue that's come up in this trial where you make a ruling, consider all the evidence. You cite to the record, and the defense keeps challenging and arguing. We would really like to get through this case.
Ms. Shrofa said, I believe that is the job.
The court said, well, your job though involves adhering to the rules. Part of the rules are that you have to listen to my rulings and conform your conduct.
Ms. Shrofa said, that's fine, Your Honor. I just wanted to make sure the court had seen 5518. If the court's ruling is after having reviewed 5518, I have no problem. Sure.
The court said, all righty.
Ms. Shrofa said, thank you.
Ms. Murray said, thank you.
Continued on next page. In open court.
The court said, sustained. You may continue the inquiry.
By Ms. Shrofa.
Mr. Barnett, when you were being questioned by the prosecutor, you were asked questions about Amy Buck. Do you recall that?
Yes.
And do you recall being asked questions about money passing through Amy Buck? You remember that?
Yes.
Amy Buck was an attorney, correct?
Yes.
And could you use that mic for me?
Sorry. Yes.
And she had an escrow account through which she allowed payments, right?
Yes, I believe so.
And it was through an attorney escrow account that the bills for Mawa were paid, correct?
Yes.
It is your understanding, is it not, that Amy Buck was hired precisely to make sure that the bills were paid?
Ms. Murray said, objection.
The court said, sustained.
What is your understanding of why Amy Buck was hired?
I don't have an understanding why she was hired. I know she was who I was required to send invoices to, but I couldn't tell you why particularly she was hired.
You would send emails to Amy Buck for payment, correct?
That's correct.
She would evaluate the document or the invoice, correct?
Ms. Murray said, objection.
The court said, sustained. So he cannot testify as to her conduct unless he was with her. Were you with her?
The witness said, no, ma'am, I was not.
The court said, go ahead.
Did Ms. Buck have follow-up questions on the invoices you sent her?
Yes, sometimes.
And did you answer those invoice-based questions for Ms. Buck?
Yes.
And after you answered those questions, did she sanction the payment?
Yes.
You were asked questions about a person named Gladys Chow, correct?
Yes.
Do you know if Ms. Chow is fluent in both English and Mandarin?
I know she speaks both. I can't tell you she's fluent, but I know she speaks both.
And do you know if Ms. Chow went with Mr. Guo when he attended meetings where there were only English speakers?
Yes.
Did you ever observe Ms. Chow translate from English to Mandarin and Mandarin to English for Mr. Guo?
Yes, in a meeting I was in, yes.
You were asked questions about whether or not you had to purchase motorcycles, you remember that?
Yes.
Mr. Barnett, was somebody forcing you to purchase these motorcycles?
No.
Were you asked to purchase them and you agreed?
Yes, I agreed.
You were asked questions about a Ducati, correct?
Yes.
And whether or not it was listed in various bankruptcy filings, correct?
Yes.
Would it be commonplace for somebody else to consult you on what would be in a bankruptcy filing for them?
Ms. Murray said, objection.
The court said, sustained.
Is it fair to say, Mr. Barnett, that boat maintenance is not part of your skill set?
Yes, that's correct.
You were asked about emails that your lawyer sent to the United States Attorney's Office, correct?
Yes.
And was Ms. Murray one of the attorneys that received those emails?
I believe so.
And did you meet with her when you were meeting with the government pursuant to your proffer agreement?
Yes.
Did she review those documents with you?
No.
Did your lawyer produce any documents to me?
Yes, sorry, yes.
Okay. When was that, do you know?
About a week ago, week and a half maybe.
And when is the first time you spoke to me?
Around right after I received the subpoena with my attorney.
Since that one time that I spoke to you, have I ever substantively spoken to you again?
Yes, I've spoken to you, yes.
No, I meant substantively about any fact in this case.
No.
You were asked questions, were you not, about supporters that came to 3cc?
Yes.
What is 3cc?
It's an office building.
And does it stand for 3 Columbus Circle?
Yes, it does.
And the prosecutor yesterday asked you if you found the whole situation there quote/unquote weird, correct?
Yes.
You were asked questions about whether people would clap for Mr. Gua. That was one of the questions, correct?
Yes.
And when you observed people clapping, was it after Mr. Gua had given a speech?
Yes.
Did you have any idea whether his speech was any good or not?
I have no idea. I don't speak Chinese.
You don't know if the applause was justified or not, correct?
Ms. Murray said, objection.
The court said, you may answer.
No, I don't.
You were asked questions about Mr. Gua holding babies, correct?
Yes.
Is he the age of a grandfather?
Ms. Murray said, objection.
The court said, you can answer.
I don't know Mr. Gua's age.
Okay, fair enough. You were also asked questions, were you not? About whether or not people brought their children and they had iPads and they worked, correct?
Yes.
And these people that the government was referring to were fellow fighters or supporters, correct?
Yes, I believe so.
And would it be fair to say, Mr. Barnett, that the staff at 3cc was not the biggest fan of these supporters coming in every day, correct?
That's correct at times, that's correct.
Right. And, in fact, you said that drove them crazy. Is that right?
Sometimes.
And is it fair to say that Yvette also wasn't a big fan of the supporter base coming into 3cc, correct?
That is correct.
Was Mr. Miles a big fan of the supporters coming whenever they wanted?
I never had that conversation with him.
Did you ever see him turn away a supporter?
No.
Did you ever see him tell a supporter, come back tomorrow?
No.
Thank you.
Ms. Murray said, Your Honor.
Mr. Barnett.
Ms. Murray said, excuse me, Ms. Schroff. I just object to the commentary, thank you. We've covered that before.
The court said, just limit it to questions, Ms. Schroff.
Ms. Schroff said, I didn't realize I said it. I'm sorry. Mr. Barnett, did you observe Mr. Gua interact with the supporters at 3cc?
Yes.
Did you observe Mr. Gua interact with supporters at his home?
Which?
In Connecticut.
Very rarely.
How about at Sherry, Netherland?
Yes.
When the supporters came to Sherry, Netherland, would they participate in the broadcast that he was putting out?
Yes, sometimes.
Did you observe Mr. Gua interact normally and socially with the supporters?
Yes.
Mr. Barnett, you were asked many questions about whether or not you had invested your retirement amount or your second loan on your mortgage or any such thing in any one of the Gua series. As the government called it, correct? You remember those questions?
Yes.
Were you interested in taking down the CCP?
Me personally, ma'am.
Yes.
Well, I mean, it sounds like a good idea, being an American, but I don't want to get political.
You were never persecuted by the People's Republic of China, correct?
I was not.
Nobody has ever tried to extradite you to a country that tortured you, right?
Ms. Murray said, "Objection, Your Honor."
The court said, sustained.
You met with Ms. Murray when you proffered pursuant to your proffer agreement, right?
Ms. Murray said, asked and answered.
The court said, sustained.
Mr. Barnett, did she ask you if you'd ever invested in any one of Mr. Gua's G series?
No, not that I'm aware of.
Mr. Barnett, when you met with Ms. Murray, did she ask you if you'd ever overbilled for the work you did for May?
No, not that I remember.
Did you overbill for the work you did for May?
No.
Did you ever get paid on an invoice for more than what work you did?
Ms. Murray said, asked and answered.
The court said, sustained.
Were all your invoices legitimate?
Yes.
Mr. Barnett, on cross-examination yesterday, you were asked questions as to whether or not you were a managing member of the Taurus Fund. Do you recall that?
Yes.
And you responded that you believed you were a managing member. Do you recall that? Do you recall saying that?
Yes, I believe so.
Mr. Barnett, isn't it true that you were not marked as a managing member on that document, correct?
I don't recall exactly what's on the document. But to my memory of it, I was just the manager of the property for the installation of security. I didn't really understand the document in full, which is.
Right. But regardless of your understanding of the document, Ms. Shrofa said, actually, you know what? Let me pull up GX Buck 1234, please. You recall the government showing you this document yesterday?
Yes.
Okay, and let's see if we can make it bigger. And if I could work down. And if I could go to page 3, which is the document that you were shown. And if I could just have that enlarged. Can you read line 5?
Yes.
And it says that the company shall be managed by, and there's a check on manager, correct?
That's correct.
And yesterday, when you were asked this question, Mr. Ferguson asked you if you were, in fact, a managing member, correct?
Yes.
And you're, in fact, not a managing member even on the document, correct?
Ms. Murray said, "Objection, Your Honor." The document speaks for itself. And Section 6 says, managing member.
The court said, sustained.
Did you see the distinction yesterday between manager and member?
Ms. Murray said, "Objection, Your Honor."
The court said, you may answer.
No, I did not see it yesterday.
Okay, thank you. How about let's go to number 6?
Ms. Murray said, again with the thank you.
Ms. Shrofa said, I'm sorry. It's just habit. Page number 6. And on number 6, on the left-hand side, it says, name and address of each manager. And what's the word after manager?
It says, or managing members.
Okay, so it's manager or managing member, correct?
That's correct.
And by the document, you were a manager and not a managing member, correct?
Ms. Murray said, objection.
The court said, sustained.
Did you realize this distinction when you answered the question yesterday? Not when Mr. Ferguson asked you the question.
Ms. Murray said, objection, Your Honor.
The court said, sustained.
Mr. Barnett, you were not the owner of Taurus Management, correct?
No, I was not.
In fact, Taurus Management is owned by Taurus Management, right?
As far as I know.
Ms. Shrofa said, we can take that down. Mr. Barnett, do you recall speaking with Ms. Murray on May 18th of 2024?
Yes.
Did you have a meeting or a phone call?
I think it was a meeting. I don't recall. I think it was a meeting.
And where was that meeting?
I believe at the U.S. Attorney's Office.
And how many people were there?
It was myself, my attorneys, and one individual from the FBI, Marie, and one other person.
The court said, please speak into the microphone.
The witness said, I'm sorry. I'm trying to remember who was in the room.
The court said, I just want you to bring the microphone closer to your mouth.
The witness said, sorry.
Mr. Barnett, at the end of that meeting, was it your understanding that you were going to be called as a witness for the government?
Ms. Murray said, asked and answered.
The court said, sustained.
Ms. Shrofa said, I didn't ask at the end of this meeting, Your Honor.
The court said, sustained.
Were you asked by the United States government to testify here?
Ms. Murray said, asked and answered.
The court said, sustained.
Mr. Barnett, between yesterday and today, have you given truthful testimony?
Yes, I have.
Ms. Shrofa said, thank you very much. I have no further questions.
The court said, is there any recross?
Ms. Murray said, yes, Your Honor. Briefly.
Recross-examination. By Ms. Murray.
Mr. Barnett?
Yes.
You testified Mr. Guo was in Mawa maybe 2 to 3 times a week after he purchased the property. Is that right?
That's correct. It was an estimate.
By the way, were there Legos at the Guo family homes?
Yes.
Who in the Guo family liked Legos?
I believe it was Mrs. Guo.
And there were a lot of Legos at Mawa, correct?
That's correct.
Ms. Murray said, Your Honor, the government offers pursuant to Government Stip 5, Government Exhibit NJ 252.
The court said, it is admitted.
Government's Exhibit NJ 252 received in evidence.
Ms. Murray said, Ms. Loftus, can we please pull up Government Exhibits NJ 111 and 354? Mr. Barnett, were there Legos at the Guo family home in Greenwich as well?
The court said, there's nothing on the screen.
Ms. Murray said, I understand. I'm just asking questions while we wait for the document to come up.
The court said, all right.
Ms. Murray said, thank you.
Yes.
Were there Lego structures at the Sherry Netherland residence as well?
Yes.
Ms. Murray said, just give a moment to pull up those documents. While we're waiting, Mr. Barnett, Mr. Guo's wife liked to work in the garden at Mawa, isn't that right?
That's correct. That's her hobby.
Starting with the photo on the left, Mr. Barnett, or both photos. Do you recognize the room depicted in these photos?
Yes.
Where is that room?
That room is immediately to the left as you enter the front door.
The front door of what residence?
Sorry. Moa, New Jersey.
Ms. Murray said, and Ms. Loftus, on the photo on the left, if we could zoom in on the items that are on the shelves, please. Mr. Barnett, those are some of the Lego structures that were at the Mawa house, correct?
Yes.
Ms. Murray said, we can take those down. You spoke some yesterday and today about the Liberty yacht, right?
Yes.
And Ms. Schroff showed you an email that you received from the Liberty yacht captain, correct?
Yes.
Your attorneys produced some of those emails regarding the Liberty to the government, right?
Yes.
And Max Krasner also received those emails, is that right?
Yes.
Ms. Murray said, Ms. Loftus, if we could please pull up just for the witness and the party's government exhibit SB 217. We could zoom in on the top so Mr. Barnett can see that. Mr. Barnett, what is this?
I'm sorry, I'm having a real hard time seeing that.
Sure. We'll try to make it larger.
That was an email that was sent to myself, Max Krasner. I don't recognize the other two names.
This is one of the emails you received regarding the Liberty yacht, correct?
Yes.
Ms. Murray said, Your Honor, the government offers Government Exhibit SB 217.
The court said, it is admitted.
Government's Exhibit SB 217 received in evidence.
Ms. Murray said, we can publish it, Ms. Loftus. We can zoom out of the top. And we can go down to the next page, please. And the next. We could just scroll through. And stop there, please. We could zoom in on the photo of the yacht itself here. Mr. Barnett, you see the word Liberty on the back of that yacht, correct?
Yes.
Do you know who picked the font for that Liberty writing on the back of the yacht?
I have no idea.
Ms. Murray said, we can take that down, Ms. Loftus. Mr. Barnett, the Mawa residence was purchased by the Taurus Fund, correct?
Yes.
And as we've established again today, you were the manager of the Taurus Fund on paper, right?
On paper.
Ms. Shrofa said, objection to her commentary.
The court said, overruled.
Aaron Mitchell gave you that paperwork to sign, right?
Yes.
He was one of Gua's family lawyers, correct?
Yes.
But you didn't own the Mawa residence in fact, isn't that right?
No, I did not.
You did not pay $24.5 million of your own money to purchase the Mawa residence, correct?
Ms. Shrofa said, assumes facts not in evidence.
The court said, overruled.
Ms. Shrofa said, he doesn't have any personal knowledge.
The court said, overruled. Ms. Shroff, if you want to make an objection, make an objection. No testimony or commentary. Go ahead.
Ms. Murray said, Ms. Loftus, can you please pull up what's in evidence as Government Exhibit NJ 807? While we're waiting, Mr. Barnett, the Liberty. The yacht that we just looked at in your photos in the emails, that was Miles Gua's yacht, correct?
Ms. Shrofa said, objection to the form.
The court said, overruled.
I don't know who bought the personal yacht.
Looking at this document, this is NJ 807, this is a residential lease agreement, correct?
Ms. Shrofa said, Your Honor, is there a question to the witness? That's an objection for me.
The court said, that is the question. Sir, do you know if this is a residential lease?
The witness said, I know it says it on there.
Ms. Murray said, and if we could zoom in on the top, please, Ms. Loftus. The tenant listed here is, I'm going to spell the name, NGOK, correct?
Yes, that's what it says.
That's Mr. Gua's wife, right?
I have no idea.
The address listed here, 373 Taconic Road in Greenwich, that's the Gua's Greenwich residence, correct?
That's correct.
And that's where you still work for Megua today, right?
That's correct.
Have you ever seen this residential lease agreement before?
Not that I'm aware of.
Ms. Murray said, we could zoom out of this, please. And we could focus on item 1, property. This indicates that the individual listed here with the last name Chi is agreeing to lease the Mawa property. Correct?
Yes, it appears that way, yes.
Ms. Murray said, we can zoom out of that, please, Ms. Loftus.
The court said, but in what role as the landlord or the tenant? I'm asking the witness.
The witness said, I'm sorry, ma'am?
Ms. Shrofa said, Your Honor. The witness has, I object because the witness has never seen this document before and is being asked to read from it.
The court said, overruled. My question is whether or not the individual is acting as the landlord or tenant of the property.
Ms. Shrofa said, Your Honor, I object to the government highlighting the document.
Ms. Murray said, Ms. Shroff, I'm not doing anything nor did I direct it.
The court said, overruled. Please answer.
The witness said, on the document it says, and tenant. Assuming they are acting as the tenant.
The court said, go ahead.
By Ms. Murray.
And on this document, Taurus Fund SP is listed as landlord, correct?
Yes, on the document, that's correct.
Ms. Murray said, we can take this down, Ms. Loftus, and go to Government Exhibit SAL 57. We could zoom in on the top. Mr. Barnett, in this bank record, which is in evidence, what is the title of the account?
Ms. Shrofa said, Your Honor, I have a continuing objection to asking a witness to read documents he has no knowledge of.
The court said, this is a document which is in evidence. It's proper to ask the witness questions about documents that have been admitted. You may continue.
The document states, Hamilton Opportunity Fund SPC. And then on the bottom of that it says, Taurus Fund SP.
And below that, what is the name of officer number 1 in this bank record?
Kin Ming J.E., if I'm pronouncing that correctly. If not, I apologize.
Do you know who that is?
I have no idea who that is.
Ms. Murray said, we can take this down. Mr. Barnett, you talked yesterday about money you received from individuals you don't know, correct?
Correct.
You understood them to be followers of Miles Gua, right?
Ms. Shrofa said, objection.
The court said, overruled. You may answer.
No, I don't know them at all.
With respect to their relationship, if any, with Miles Gua, you understood them to be fellow fighters. Right?
Ms. Schrofa said, objection.
I really don't have any knowledge.
The court said, asked and answered. You may continue.
You also talked about your GoFundMe account, right?
Yes.
And the purpose of that was to fund your attorney's fees, correct?
That's correct.
Because you were sued in the bankruptcy proceeding relating to the Guasmawa residence, right?
That's correct.
And it's expensive to defend yourself in a lawsuit, right?
Yes, it is.
One of the people who sent money to your GoFundMe was Chidong Xia, XIA, or Brother Long Island, correct?
I don't have that list in front of me, so I'll take your word for it.
You've driven that person before, correct? Long Island David, Brother Long Island?
Oh, yes, that's correct.
Mr. Barnett, you don't have a view of the Chinese Communist Party, do you?
A personal view, ma'am.
Correct.
I guess I do. I don't know if you want me to share that.
You don't view yourself as a freedom fighter against the CCP, do you?
No, I do not.
You're not a member of the NFSC or the new federal state of China, right?
No, I'm not.
You've seen some of the comments that are posted on the GoFundMe page that you have, correct?
Yes.
Comments from people who sent you money, right?
Yes.
You're aware that people sending you money referenced your fighting against the CCP, correct?
Yes, I believe I saw that.
Mr. Barnett, you don't take any actions to fight against the CCP, do you?
No, not personally, no.
Ms. Murray said, may I have a moment, Your Honor?
The court said yes.
Counsel conferred.
Ms. Murray said, nothing further. Thank you.
The court said all righty.
Redirect examination. By Ms. Schrofa.
Good morning again, Mr. Barnett.
Good morning.
Mr. Barnett, you were shown pictures of Legos, correct?
Yes.
And you were asked questions about where there were Legos, in which places, correct?
Yes.
Does Mrs. Gua speak English at all?
Not to my knowledge, no.
When Mrs. Gua travels, doesn't she take Legos with her?
I believe I've seen that once, yes.
And, in fact, no matter where she goes, she takes Legos with her because she does Legos, correct?
She does do Legos. I only can verify the one time I saw her take Legos.
And Mr. Barnett, isn't it fair to say that another thing that she does is garden, correct?
Yes, quite often.
And would it also be fair to say that both activities do not involve the use of English, correct?
No.
I really would like it if you would help me and keep your voice up or use the mic.
Sorry.
That neither activity involves the use of English, correct?
No.
When Mrs. Gua gardened at Mawa, do you recall what it is that she was growing or attempting to grow?
Ms. Murray said, Your Honor, objection to relevance. This is redirect.
Ms. Schrofa said, this is what she brought up, gardening.
The court said, it's within the scope of gardening.
You know what? I'll rephrase that question for you, Mr. Barnett. Is it fair to say that Mrs. Gua was trying to see if they could implement a vegetable garden at Mawa?
The court said, you may comment on whether you know if it was vegetables or something else.
They looked like vegetables. I'm not a gardener myself, so I don't.
And it was huge, right?
Yes, it was.
Could feed 20 or 30 people, correct?
Ms. Murray said, objection, Your Honor. Speculation.
Could it feed 20 or 30 people?
The court said you may answer.
I don't know.
You were asked questions about SB 217. Ms. Schrofa said, you know, Ms. Loftus, if I may impose upon you, it might just... Oh, you have it? Thank you, Jorge. You were shown these pictures, right?
Yes.
Do you know anything about this boat?
Yes.
What do you know about it in a nutshell?
The only things I know about it were the mechanical issues with the boat. That's the most knowledge that I have of the boat. And the only reason I know that is from the conversations I had with the captain at the time.
Okay. Ms. Schrofa said, "Thank you. We can take that down." Ms. Murray asked you questions about whether or not Aaron Mitchell gave you paperwork to sign, correct?
Yes.
Did Mr. Mitchell make you sign those documents in front of him?
No.
Did he give you time to read them?
I believe so. They were sent to me via, I don't know if it was email or WhatsApp, but yes.
Do you know how much MAWA costs?
I do now.
No, before the government told you. Did you know how much MAWA costs?
Ms. Murray said, objection.
The court said, overruled.
I had a guess on what it cost.
Nobody shared the price with you, right?
Not that I remember.
Okay, let's look at NJ 807. Do you recall being shown this document?
Yes.
And Mr. Horton had a portion highlighted for you.
Ms. Murray said, objection, Your Honor.
Ms. Schrofa said, and I'd ask that the same portion be highlighted now.
The court said, so no testifying.
You see that name there where it says between landlord and tenant, correct?
Yes.
All right. So this document, you correct me if I'm wrong, is a residential lease agreement, okay? And the tenant is going to be Miles Gua's wife. Is that right?
Yes, that's correct.
And she is going to rent. What contraption is she planning to rent in this lease agreement?
Ms. Murray said, speaks for itself.
The court said, you're asking what property is being rented?
Ms. Schrofa said, yes.
The court said, go ahead.
Ms. Schrofa said, let's keep scrolling down and let's go to paragraph number 1.
According to the document, it says 675 Ramapo Valley Road, which is the residence in New Jersey.
Okay, so Miles Gua's wife is going to rent MAWA?
Ms. Murray said, asked and answered.
Ms. Schrofa said, I'll move on.
The court said, sustained.
Ms. Schrofa said, we can take that down. Let's look at SIL 57. You were asked questions about. You actually were just asked to read this document, right?
Yes.
Okay. And do you have any information about anything on this piece of paper?
No.
Okay. Ms. Schrofa said, we can take that down. You were asked questions about somebody named Kim Ming Jae. And then you were asked questions about your GoFundMe account, right?
That's correct.
Okay. You were also asked a question, were you not, about your views on CCP?
Yes.
Could you tell us your views on the CCP?
My personal views on the CCP are based on what I've read and what I've heard newswise. They are based on principles that I don't agree with, which is oppressing people. I don't really know how else to expand on that without, I don't agree with their philosophies of how they treat their people.
And if somebody sent you money because they wanted to support your philosophy, would there be something wrong with that?
Ms. Murray said, objection.
The court said, sustained.
Mr. Barnett, the people who sent you money on your GoFund account, they left comments for you, correct?
Yes.
And each comment, how did you receive those comments, in a positive or negative way?
I received everything that I received in a positive way.
And Ms. Murray asked you questions about Long Island David, correct?
Yes.
And he supported you on the GoFundMe page, is that right?
Yes.
Did he ask you for anything in return?
No.
In fact, did anybody who gave you money on your GoFundMe page ask for anything from you in return?
No.
And the last question you were asked by Ms. Murray was whether or not you had taken any actions against the CCP, correct?
Yes.
Do you know of an action an American citizen can take against the CCP?
Ms. Murray said, objection.
The court said, sustained.
Mr. Barnett, would you be supportive of actions against the CCP?
If they were taken by the U.S. government, I would be.
How about if they were taken by people?
It depends on what those actions were, ma'am. If they were legal actions, then I don't have an issue with that.
And you'd support them, right?
Yes.
Thank you. Ms. Schrofa said, I have nothing further.
Ms. Murray said, nothing further.
The court said, all righty, sir. You may step out of the courtroom.
The witness said, thank you. Witness excused.